Have you ever had an attorney from the US Trustee Program show up to one of your 341 meetings and start asking your debtors questions,
Yes.
right? And it freaks debtor attorneys out, obviously.
Yes.
It's like, well, why are they showing up? Like, what's happening, right? Here with Larry Friedman, former director of the US Trustee Program. Let's talk about one, why they show up, what it could mean, and then how a debtor attorney should handle it. I've had people, debtor attorneys, where attorney has shown up from the US Trustee Program at their 341, and just because they showed up, they have voluntarily stopped collecting payments. They've changed their practice completely without ever an inquiry, without anything. So I just, obviously that's an extreme example. But let's unpack this. Why do they show up?
Well, usually because they're curious about something, either in the debtor's case in particular, or in your handling of this debtor's case and maybe perhaps other debtor cases.
Mm-hmm.
If the question is about a particular case, they're like any other creditor. They'll just start asking questions of the debtor, and they're looking for information specifically with regard to that case. So those kind of questions would be like, you show this on your schedules, but you don't show that, or this information on your schedules conflicts with your testimony, or this information on your schedules conflicts with other information on your schedules. That's one kind of inquiry. The other kind of inquiry is where they start to say, when did you sign this agreement with your attorney? How long did you meet with your attorney for? Those are questions that are definitely going to process and to consumer protection issues. So you need to recognize the differences between those two kinds of inquiries, and you'd handle them differently. But in each case, I think you want to get the facts straight. So the debtor is required to answer the questions of the 341 hearing, but you should immediately let the attorney know from the program that you're happy to sit with the program, you're happy to have them talk to your client, but that you think that it should not, the time at the 341 hearing is not the right time for that. And if they would simply contact you after the 341 hearing, you arrange for a meeting with the program. That's one.
Mhm.
If the questions are about your processes, and you would understand that because the question is about, gee, when did you sign this retainer?
Right.
What did you understand the fee was going to be? How long did you meet with your attorney? What did what did he tell you about this process? And, those kinds of questions, those are things where, I don't think they're appropriate for the 341 hearing. And I think that you should tell the program that you'd love to meet with them to discuss it and to understand what their concerns are, but that you're more than happy to do that at a time that doesn't take up time of the 341 hearing.
So if you do that, if you ask for a separate time, does that mean that the 7 doesn't get discharged? I mean, are you
No,
pushing out?
not at all.
Oh, it doesn't.
Not at
Okay.
all.
So
If the inquiry is about the case in particular,
right.
whether or not the debtor is going to get an expedited discharge, when I say expedited, I mean the normal course of events, say 90 days from the date of the first
Mhm.
scheduled 341 hearing,
Mhm.
that's triggered by the filing by the case trustee of a report of no distribution.
Mhm.
Okay?
Okay.
So that's the discharge side of it. The rest of it, is outside of that.
So it doesn't slow down the case by saying, let's have a side conversation about it. That's what I'm trying to get at.
Not at all.
Okay.
If there's gonna be an objection to the discharge, the program's gonna ask you, or if they want a further investigation, the program's gonna ask you to stipulate, just
Mhm.
like a creditor would, to an extension of
Okay.
time to file
Mhm.
a dischargeability complaint.
So either way, whether it's regarding the case or your processes, you want to move that away from the 341. I mean, it would be very uncomfortable for the debtor
Yes,
to get like grilled
yes. You want to advise your
publicly.
client, because
Yeah,
your
you got,
client's sitting there going, "Heck is going on?"
well, the client's going to think you didn't tell me this was going to happen. You said it was going to be a 5-minute conversation.
Right,
And all of a sudden, like, wait,
right,
I got another attorney grilling me. What's not the judge or the trustee?
right.
Right? It's
Exactly.
so either way, your advice to counsel would be if an attorney from the US Trustee Program shows up to your 341, listen to what it is and say, let's take this offline and we can talk about it, gladly talk about it once again with humility hey, I'd gladly talk about it, but let's not do it right now so I can speak to my client or whatever. Is that
And that's
correct?
a little more yes, and that's a little bit more justified in today's world where these are telephonic 341 hearings. When it used to be when everybody was meeting in a hearing room, you'd see that an attorney from the US Trustee Program was in the hearing room.
Yeah.
And if they come sit at the table when your case is called, you know that they're there about that case.
Yeah.
And you could, talk to them about it. You can't do that in these telephonic settings. They're not even Zoom settings, they're telephonic settings.
Yeah.
So you don't even know. Right. So all the
Larry,
more reason to deal with it later.
Larry, why would they show up? Like, is this a precursor to an inquiry? Is this a precursor to a letter? Like, should like on a scale of 1 to 10, 10 being like, hey, watch out. Where is this when they show up? Is it well, it's random? Like, where would you rate it in terms of like concern?
I would say it's never random.
Oh, it's not.
They either have a question about the specific case
Yeah.
or they have a question about the way this case was handled with regard to your processes in all of your cases that you're filing.
But what I'm saying is do you think it's a random spot they notice something like a quality control check, or is this like a systemic potential problem?
Well, it depends. I mean, it's going to generally start with one flag. Something happened that caused your case or your
Mhm.
cases to come to the attention of the program.
Yeah. Larry, what other feedback would you give a debtor attorney if this happens and you meet with them on the side and they realize they're asking questions regarding your process? Take a close look at your process, right? Like shift the process based on the feedback you're getting, or whatever. I don't know. I'm just asking. As a former director, what are you looking for to checkbox, move on to the next case?
The most important thing is to understand that your client's going to have a great deal of anxiety as a result of this question
Mhm.
if this happens at a 341 hearing. So the first thing you need to do is counsel your client
Mhm.
and as to what's happening and put them at ease
Yeah.
and be sure to assure them that A, you have this under control, and that B, if there's anything in the process that the government, the US Trustee Program, would perceive as unfair to the debtor, you're willing to make it right, but you need to meet with the program to find out exactly what their inquiry is.